Good morning, can you hear me?
Yes, I can hear you.
Hi, what is your name, please?
Ryan Fox.
What? Oh, I've got it. Your case is at 9:15.
It is at 9:15. Okay, because I thought it said 9 and then it said to be 15 minutes early, and I was going to try to be just 20 minutes.
Yeah, so you
Make
can
sure I
stay
had
here or
everything.
you can come back, whatever you want to do.
I'll just stay here since I've got everything, just in case so it doesn't kick me out again.
Okay, that's fine. I'm just gonna just keep yourself muted, and when your case is called, just unmute yourself.
Okay, thank you.
Yep, you're welcome.
You're right there. Okay.
Hello. Madam Clerk, we have a consent whenever the court's ready. Thank you.
Okay, yep, the judge is on her way out.
This is 2403314 LT MSR Holding versus Jamie Landers. Would you state your names for the record, please?
Morning, Your Honor.
Yeah.
Father Packer on behalf of MSR Holding LLC, the plaintiff.
Jamie Landers.
Thank you, Mr. Landers. Today is the day and time scheduled for the adjourned hearing in this matter. Have the parties had an opportunity to speak?
Yes, Your Honor, we have resolved this case and have a consent to put on the record.
Please proceed, sir.
Thank you, Your Honor. From originally pled, Mr. Landers and his, I think his wife or significant other has made multiple payments, which has brought the rent balance down to $1,450 as of today, and that does include the June rent for 2024. There's a water bill owed to the municipality in the amount of $108.76, and then statutory costs and attorney fees of $235. The grand total is $1,793.76. The writ date is June 24th. And also, if not paid, a money judgment would be entered in this case as one was pled. And then I did explain to Mr. Landers his 3-day right of his rescission as well as his appeals rights that runs with the writ date.
Thank you. Mr. Landers, were you able to hear the attorney just now?
Yes, ma'am.
And that's what you wish to agree to?
Yes, I do.
And sir, you weren't present at the original hearing in this case. Have you had the opportunity to review the rights available to you in this landlord-tenant matter?
Yes, I have.
Do you have any questions about the rights available to you?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Do you have any questions about these proceedings?
No, ma'am.
Then the attorney's office will prepare a consent judgment that lists the terms that he just placed on the record with a total due of $1,793.76, which is inclusive of June rent, the unpaid water bill, and the court costs due. It will indicate that you will pay this amount or vacate the property by June 24, 2024. When I receive it, so long as those are the numbers listed on the form, I will sign it and a copy will be mailed to you at the address we have on record. Do you have any questions, Mr. Landers?
No, ma'am.
Anything else on behalf of MSR Holding?
Nothing, Your Honor. Thank you.
Thank you. Then that concludes this matter. Mr. Landers, you're free to go. You have a great afternoon.
Thank you.
Thank you, ma'am. Thank you, sir.
Have a great day. Thank you. Have a great day.
Yep.
Thank you. This is 2402763 LT Royal Village versus Joe George. Would you state your names for the record, please?
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Royal Village. I see that my client is here. Okay.
Sir, would you state your name for me, please?
Bob Joe George.
Thank you, Mr. George. Today is the day and time set for hearing in this matter. It seems that the parties last appeared on May 8th, 2024, at which time Judge Oakley recused himself and scheduled this matter to continue in this courtroom this morning. Have you spoken or do you need a minute to speak?
Your Honor, we were put into a breakout room. I was talking to Mr. George, trying to understand what his position was on this. He intimated that I was bullying him, which is the first time someone's accused me of that in quite a long time. It's a pretty straightforward non-payment of rent case. I'm not sure where he's coming from, Judge, except he's stated he wants to get an attorney now. So I tried to discuss it with him, but I couldn't get anywhere, so.
Mr. George, your position, we're not at a stage of taking testimony or anything of that nature. Just what is your position regarding this matter and
Your Honor, I do construction work. I've lived here for 35 years. I've never had to go to court or had a dispute over the rent. Miss Brown knows very well in the winter months I get back a little bit, in the spring I catch up. So when I was aware when she decided to take me to court this year, I wasn't, normally she just always threatened me, get me some money in early spring, and if not, you're going to have to go to court. Well, this year she didn't call me. She just said, I told her when I come home, Linda, as soon as the plants open up, 1st of May, I'll start get your money in real quick like I normally do. That was the last conversation. Then here comes the court papers for me to go to court being evicted for the rent. Well, when I saw on the court papers from the lawyer that my rent is $430 a month and I've been paying her $460 for the last 4.5 years, oh, I was very upset because I trusted her. She tells me whatever I owe her. My wife prior to this would handle the bills. Make a long story
Mr.
short.
George?
When I
Mr.
went to
George,
court-
I'm sorry. I'm interrupting you only because there are 30 cases scheduled this morning, and I started by saying we're not taking testimony. No, you're fine. But if your issue is a dispute as to the balance,
Yes,
or
so-
hold on, let me finish asking the question, Mr. George.
Sorry.
You have a dispute as to the balance, and then
Yes.
Mr. Robinson intimated that you wanted to get an attorney.
Yes, because he told me that this is being settled today and I'm being evicted in 10 days if I don't pay this money. And I'm like, but she never straightened out or organized what I owed her and showed me cause. That's what the last court date was. I gave $1,000 in good faith. And then I said this week, this new court date, she was supposed to adjust the price of what I owe. So then she didn't do that. So now we're going to have to go to court. I got proof of evidence what I paid her and I want this straightened out. I'm not going to pay more than I'm supposed to pay. And she's been overcharging me. That's not fair.
Okay, let me say this.
So I would like
In
to
your
think-
conversation, hold on. In your conversation with Mr. Robinson this morning, did you even discuss the balance?
Yeah, go ahead. I'm sorry, Your Honor.
My question is, did you discuss the balance with Mr. Robinson this morning?
Yes. He
And you're
told me
still in
to work
disagreement?
off me.
I can't, if I'm talking, I can't hear you.
Oh, sorry.
No. And sir, you dispute the balance.
Yes.
Have you made efforts to be in contact with an attorney yet?
No, I didn't think I needed one. I thought she was going to adjust the balance of what I owed, and then I would find out today. That was what we discussed at the last hearing.
Okay, Mr. George, there are people here from Lakeshore Legal Aid, which is a legal services organization. I don't know if they're available to do screenings this morning. If they are, we'll get you into a breakout room with it.
If I could get a continuance, I'm going to hire an attorney. My family's going to help me out, and we're going to get an attorney. I got the proof of evidence, my receipts, and she's been just overdoing it and overcharging me, and it's not fair. It's not right. I've been a good resident for 35 years here. I shouldn't be treated this way.
Okay, so you're saying no to Lakeshore, you're going to retain a private attorney. How long will it take you to have your attorney, sir?
I should probably be able to get everything going within a week or two. I don't know for sure because I've never done this before, Your Honor. I've never been
Okay. Then, Mr. George, we will adjourn this matter over to June the 25th at 11 a.m. That's back here with me in courtroom number 1. If you retain an attorney, they will know that they need to file an appearance with this court so that we know that they are involved. That's
Okay, right.
June the 25th at 11 a.m. back here with me in courtroom number 1. Same Zoom meeting ID information that you used to log on this morning. If I'm not asking for any more conversation about it, but if your numbers reflect something even close to what Mr. Robinson has, and he has sent you a ledger, or they provided you with a ledger,
No, they
and you're able
haven't.
to work it out, fine.
They haven't provided me with the letter. That's what I asked for, and they
You have
didn't.
to come into the office to get that.
I didn't ask you, ma'am.
Sorry.
No. If it's that simple and we're back in 2 weeks, maybe between now and then, that information can be provided. And Mr. George, there might be a simple explanation for the difference in the numbers. I'm sorry, Mr. Robinson, was there anything else?
Yeah, based on that, Judge, Mr. George, if you could just go to the office, Linda will provide you a ledger. You are going to need that anyway to show your lawyer, okay? So maybe when you took a look at that, that may help clarify things, okay?
Okay,
Thank you. Thank you, Judge.
Thank you. Mr. George, that concludes this matter. I will see you on June the 25th at 11 a.m. by Zoom for courtroom
Thank-
number 1. Have a great afternoon, okay, sir?
thank you.
Thank you, Judge.
You're welcome.
Have a good day.
You too, ma'am. Ms. Duff, this is 2403305 LT Bill Villa Meadows versus Elisa Duff, Jennifer Parker, and Pamela Hobson. Would the party state their names for the record, please?
Alex Lubianski, P 77121 on behalf of plaintiff.
Alyssa Duff.
Pamela Hobson.
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. When we were here on May the 29th, the case was adjourned for payment. Where do we stand this morning, sir?
Your Honor, we do have an agreed upon consent judgment with two of the defendants who were able to come to court. I would ask the court to enter the same as a default for the third defendant. Amount of rent currently due, $2,514, costs of $304.88 for a total of $2,818.88 with a writ date of June the 24th. I did explain MCR 4.201 to both defendants who are present. Both of them gave me their permission to sign on their behalf. And defendant with the last name of Parker is unable to join due to work.
Ms. Duff and Ms. Hobson, were you able to hear the attorney just now?
Yes.
Is Ms. Hobson with you?
Yep,
Yeah.
she said at the same time.
Oh, okay, thank you. I just need to hear you separately. And was that an accurate statement as to the agreement you've reached this morning?
Yes.
Yep.
And you were here last time and watched the advice of rights video.
Correct.
You can't speak at the same time.
Yeah.
Yeah.
Thank you. Do you have any questions about the rights available to you?
No.
Do you have any questions about the consent judgment that was just placed on the record?
No.
Do you have any questions about today's proceedings?
No.
Nope.
Then the attorney's office will prepare a consent judgment that shows past due rent of $2,514, cost of $304.88, a total judgment of $2,818.88, with an indication that you will pay this amount or vacate the property by June the 24th, 2024. So long as the document presented to the court has those same numbers, I will sign it. A copy will be mailed to you at the address that we have on file. As for Ms. Duff and Ms. Hobson, it will show as a consent judgment. As for Ms. Parker, it will show as a default judgment based on the fact that she did not appear this morning and she did not appear back on May the 29th. Nothing will be different, just the indication of the agreement versus the failing to appear part, okay?
Okay.
Okay.
Any questions, Ms. Duff?
Nope.
No.
Any questions, Ms. Hobson?
She said no.
You're free to go. You have a great day. Thank you.
Thank you as well.
This is 2403308 LT. This is Bell Villa versus Derek Cavens Moore. Your appearances, please.
Alex Lubianski, P 77121 on behalf of plaintiff.
Thank you. The last time that we were here, back on May the 29th, the court adjourned the matter as Mr. Cavens Moore went in to speak with Lakeshore Legal Aid. I'm just looking in the breakout rooms to make sure there's nobody in there. When he was released, the indication was that regardless of what happened with Lakeshore, that he would need to appear on this day for an adjourned hearing. The court has not received an appearance from Lakeshore, have not received any communication from the defendant to explain his failure to appear this morning. Case was scheduled at 9 o'clock. It's now 9:28. By this court's clock, how would you like to proceed, sir?
Your Honor, remove for a default judgment of possession only. Amount of rent currently due $3,864. Court costs $247.14 for a total of $4,111.14 with a writ date of June the 24th.
Thank you. Default judgment will enter in that amount based on the defendant's failure to appear. Total judgment of $4,111.14. Please have your office submit that judgment for entry.
Thank you, Your Honor. We'll see you later this morning.
Thank you. I'll see you in a little bit. Good morning, sir.
Good morning, Your Honor. Are you talking to me?
This is yes.
Sorry. Okay, I didn't know.
No, you're okay. No, you just popped in, so I figured you were ready with something.
I'm
This
ready
is
with
24.
Sorry, I'm
I'm
sorry. Your
sorry.
Honor.
The case I was about to call 2403426 West Village versus Foster. Your appearances for the record, please.
Good morning, Your Honor. Ali Risk on behalf of the plaintiff.
Ma'am, state your name for me, please.
Sahaja Marie Foster.
Ms. Foster, are you represented by Lakeshore?
Yes,
Yes, Your
ma'am.
Honor. Patricia Prutnick, Your Honor, on behalf of Ms. Foster.
Thank you, Ms. Prugnick. The court did not see an appearance from you in this matter. How are we proceeding this morning?
Your Honor, so it's my understanding that Ms. Foster has applied for renter's assistance either Friday or Monday. She is awaiting the status of that application, so I'm assuming that we'll adjourn this out for another court date.
Is that correct, Ms. Prugnick?
It is, Your Honor. The form was filed as well.
The 539 was filed with the court?
Yeah, the 539 was filed with the court, yes.
Okay. I reviewed the files yesterday afternoon. I didn't see anything in there, but if you're saying it's filed, it's filed. If it's not, please ensure that it's done within the next 5 days. The court will adjourn this matter over to Tuesday, June the 25th at 11 a.m. for status regarding the application for rental assistance. That adjourned hearing will be back on Zoom, back here in courtroom number 1, June the 25th at 11 a.m. Is there anything else on behalf of West Village?
No, thank you, Your Honor.
Anything else on behalf of Ms. Foster?
Nothing further, Your Honor.
Thank you. Ma'am, you're free to go. You have a great day. I'll see you on June the 25th at 11 a.m.
Okay, thank you, ma'am. Have a good day.
Thank you. 2403428 LT West Village Estates versus Fox and Fox.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
Have you spoken to the Foxes? They're in your waiting room, it looks like.
I did, yes, Your Honor.
Let me get them out here. Hold on, let's get them out here.
Okay.
In the Fox matter, please turn on your video, unmute yourself and state your name for the record.
Ryan Fox.
Thank you, Ms. Fox. Today is the day and time scheduled for the adjourned hearing in this matter. When you were here on June the 5th, you went to speak with Lakeshore Legal Aid. Are they representing you this morning?
No, they are not. I was misunderstood with what they were doing. I thought they were more rental assistance and not legal. So I'm just with myself.
Have you spoken to the attorney this morning?
Yes, I have.
Is there some agreement, Mr.
Yes.
Yes, Your Honor. We do have an agreement in the form of a consent judgment. The defendants will pay $1,510.69 in back rent, court costs of $233.71 for a total of $1,744.40 on or before June 24th, 2024.
Ms. Fox, were you able to hear the attorney just now?
Yes.
And that's your agreement and understanding?
Yes.
And ma'am, when we were here back on June the 5th, there was a video that played that explained the rights you have available to you in this landlord-tenant proceeding. Do you remember that video?
Yes, ma'am.
Do you have any questions about the rights available to you?
No, ma'am.
Do you have any questions about the consent judgment?
No.
Do you have any questions about today's proceedings?
No, I do not.
And Mr. Rick's office will prepare a consent judgment that shows a total due of $1,744.40. It will indicate that you will pay this amount or vacate the property by June the 24th, 2024. So long as the document that he files with the court has those same numbers and dates, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of West Village?
No, Your Honor.
Is there anything else, Ms. Fox?
No, Your Honor.
There was a second defendant on this case that has not appeared twice now. The judgment will show as a default judgment as to that person. Other than that, ma'am, you're free to go. You have a great day.
Thank you. You as well.
Thank you, Your Honor.
Thank you. This is, did you speak to Knox as well?
Yes, Your Honor.
Let's get Knox out here.
I'm pulling them.
You're fine. Thanks, Marianne. This is 2403443 LT. This is West Village versus Amari Knox.
Good morning, Your
Yes.
Honor. Ali Risk on behalf of plaintiff.
Well, that's the only thing you try to do. That's the only thing you try to do to scare me and make me feel bad. That shit don't work. That shit don't work.
Hey, Mr. Knox, whoever's in the car with you is being
Yeah,
recorded and
we-
streamed, sir.
Oh, okay. I was about to say, yeah, I'm at work. That's why. I mean, I'm sorry.
That's okay.
Yes.
Sir, when we were here back on June the 5th, you went into a breakout room to speak with Lakeshore Legal Aid. Are they representing you this morning?
Yes.
I called the case and an attorney did not respond on your behalf. What's your attorney, sir?
Oh, my attorney. I don't know. Hold on. The attorney. Is it on the paper? Is it
Better chill out, Pep.
Excuse me, Your Honor.
Hold on. If I'm not calling your case, if I'm not talking to you, please keep yourself muted. Yes, ma'am.
I work with Lakeshore Legal Aid. We actually sent him a letter informing him that we don't have the resources to be able to represent him in this matter.
I
Thank you,
didn't
Ms.
get your-
Becker.
You sent me a letter in the mail?
Over email, sir.
Oh, over the email? Oh, okay. I didn't know that. Okay.
Mr. Knox, did you speak to the attorney this morning, Mr. Risk?
Your Honor, we did communicate. Like I said, no, there was no attorney that appeared on behalf of him. I spoke to him directly. But we did reach an agreement in the form of a consent judgment. And I could state the terms on the record if you'd like to proceed, Your Honor.
Would you please, sir?
Yes, Your Honor. There is back rent in the amount of $4,818.17. Court costs in the amount of $182.68 for a total of $5,000.85 with a writ date of June 24th, 2024.
And you said consent judgment?
Yes, Your Honor.
Mr. Knox, were you able to hear Mr. Risk just now?
Yeah.
Sir, that was the agreement that you reached with him?
Yes.
Yes is the answer, sir, actually.
Yeah, I said yes.
You said yes are two different things. That's
Oh,
all.
I thought I said yes. I'm sorry.
Thank you. And sir, when you were here back on June the 5th, there was a video that played that explained your legal rights. Do you have any questions about the rights available to you this morning?
No, I don't.
Do you have any questions about the consent judgment?
No, after I talked to him, no.
Do you have any questions at all about these proceedings?
No, I understand what he was telling me, and I gotta hurry up and try to pay it before the 24th.
Thank you. The Mr. Risk office will prepare a consent judgment that indicates a total due of $5,000.85 that you will pay this amount or vacate the property by June the 24th, 2024. So long as the document he forwards to this court has those same numbers on it, the court will sign it and a copy will be mailed to you at the address we have on file. Is there anything else, Mr. Risk?
No, thank you, Your Honor.
Anything else, Mr. Knox?
No.
You're free to go, sir. You have a great day.
Thank you, too.
Thank you. This is 2403444 LT, West Village versus Harold Lyles. Appearances, please.
Good morning, Your Honor. Ali Risk on behalf of plaintiff. And Mr. Lyles
State your name
was here.
Thank you, Mr. Lyles. When we were here back on June the 5th, you went into a breakout room to speak with Lakeshore Legal Aid. Are they representing you this morning, sir?
No, they're not.
Have you had the opportunity to speak to the attorney this morning?
Yes, I did.
Did you reach an agreement, Mr. Risk?
Yes, Your Honor. We did reach an agreement also in the form of a consent judgment. The back rent is $2,781.70. Court costs are $182.68 for a total of $2,964.38 to be paid on or before June 24th, 2024.
Mr. Lyles, were you able to hear Mr. Risk just now?
Yes, ma'am.
And that's an accurate statement of the agreement you reached with him.
Yes.
And sir, you were here back on June the 5th when there was a video that played that explained the legal rights you have available to you.
Yes.
Do you have any questions about those rights?
No.
Do you have any questions about the consent judgment?
No, ma'am.
Do you have any questions about today's proceedings?
No.
Then his office will prepare a consent judgment that has the terms that were just placed on the record. So long as those numbers are identical to what he just provided, the court will sign the judgment and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of West Village?
No, thank you, Your Honor.
Anything else, Mr. Lyles?
No, Your Honor.
Mr. Lyles, that concludes this matter, sir. You're free to go. You have a great day.
Thank you.
This is 2403489LT, the Maxwell versus Hope Gaines.
Mr. Joseph is in a breakout room, Judge.
Thank you. 2403456LT, West Village versus Kirk Starsky.
Oh, my goodness.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
Could you state your name for me, please, sir?
Kirk Starsky.
Thank you, Mr. Starsky. When we were here back on June the 5th, the parties asked the case to be adjourned so that payment could be made. Have you had an opportunity to speak to the attorney this morning, sir?
No, ma'am.
Oh, well, let's get you moved into a breakout room with Mr. Risk. Will you come back out? We'll get your case recalled, sir.
Thank you, Your Honor.
And then, Mr. Risk, I don't do
Yes.
defaults until about 15 minutes after the scheduled start time. So your 9:30 block has Felicia Howard and Kelly Kirkland. When you come back out with Mr. Starsky, I'll call all of those cases.
Okay, thank you, Your Honor.
You're welcome. Yes, Ms. Gaines.
When the hosts mute me, can they unmute me too? Because I'm having trouble issue with my phone, and I would like to not be muted because I'm having too many troubles unmuting myself. I'm gonna be quiet.
Ms. Gaines?
Yes, ma'am.
Thank you. I was gonna say, the only reason why I muted you was because you were talking when I was in the middle of another case. But if you
I'm
sit
sorry.
there quietly, no, it's fine. I understand. You're fine. Have you already been in to speak to the attorney?
Yes, ma'am.
Then when Mr. Joseph comes out, we'll get going with you.
Yes, ma'am. I'll be quiet.
Thank you. Oh, Mr. Joseph is out. This is 2403489LT, the Maxwell versus Hope Gaines. Your appearances, please.
Good morning, Judge Joe Joseph for plaintiff.
State your name for me, ma'am.
My name is Hope Gaines.
Thank you, Ms. Gaines. When we were here back on June the 5th, you were put into a breakout room with Lakeshore Legal Aid. Will they be representing you this morning, ma'am?
Yes, ma'am. No, ma'am.
And ma'am, you had the opportunity to speak to Mr. Joseph.
Yes, ma'am.
Mr. Joseph, did you reach an agreement?
Yes, Judge, we have a consent judgment for possession only. Rent retain is $1,711. Court costs are $170. That totals $1,881 with a writ date of June 24th. I've gone over Ms. Gaines's rights under 4.201 regarding the 3-day rescission rule. She's also given me her authorization to sign her name to this agreement.
Ms. Gaines, is everything Mr. Joseph said accurate?
Yes, ma'am.
And ma'am, you were present back on June the 5th when there was a video played that explained the legal rights you have in this case. Do you remember that
ma'am.
video?
Yes, ma'am.
Do you have any questions about your rights?
No, ma'am.
Do you have any questions about today's proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then Mr. Joseph's office will prepare a consent judgment that has the terms that he just placed on the record, so long as the document received by the court shows a total of $1,881 payable by June the 24th, 2024. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this matter, Mr. Joseph?
Nothing further from plaintiff. Thank you.
Anything else, Ms. Gaines?
No, thank you.
Ms. Gaines, you're free to go. You have a great day.
You too. Bye-bye.
Thank you. Mr. Joseph, you're the 9:45 block, so I'll finish the 9:30 block. I'll get back to you in just a second.
Okay, yeah, we have two consents on the ones that are here, and there's one that hasn't checked in yet, so
Okay, thank you.
thank you.
Were you expecting Mr. Starsky to come back out?
Yes, Your Honor, we did reach an agreement.
Mr. Risk, you're a co-host, so I don't know if you would, if you're done speaking with people, you just remind them to return to the main session or move them back to the main session. This is a recall of 2403456. Mr. Starsky, you were in a breakout room with Mr. Risk.
Yes, ma'am.
Did you reach an agreement with him?
Yes, ma'am.
The terms of the agreement, Mr. Risk.
Yes, Your Honor, there's back rent in the amount of $1,686.31, court costs of $182.68 for a total of $1,868.99 to be paid on or before June 24th, 2024.
Thank you. Mr. Starsky, was that an accurate statement of the agreement you reached with Mr. Risk?
Yes, ma'am.
And sir, you were present back on June 5th when there was a video that played that explained the legal rights you have in this matter.
Yes, ma'am.
Do you have any questions about those rights?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Do you have any questions about today's proceedings?
No, ma'am.
Then Mr. Risk office will prepare a consent judgment that shows a total due of $1,868.99 with the indication that you will pay that amount or vacate the property by June the 24th, 2024. So long as the document he submits has those identical numbers, I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else, Mr. Risk?
No, thank you, Your Honor.
Anything else, Mr. Starsky?
No, ma'am.
That concludes this matter, sir. You have a great day.
Thanks, you too.
Thank you. This is 2403442 LT, West Village Estates versus Kelly Kirkland.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
Today was the day and time scheduled for the adjourned hearing in this matter. The case was first heard on June the 5th. This case was scheduled at 9:30 this morning. It's now 9:47 by this court's clock. Defendant has failed to appear, sir. How would you like to proceed?
Your Honor, so defendant is here under the name Kelly Smith. I'm
Ma'am?
not sure.
Yes,
Oh, state your name for me, please.
it's Kelly Smith. On the documents, it's Kelly Kirkland, because when I initially signed up to move there, I was Kelly Kirkland, going through a divorce. And I took back my maiden name, and they haven't switched it back to my maiden name.
Thank you, Ms. Smith. And thank you for that clarification, Mr. Risk. Ma'am, you had the opportunity to speak to the attorney this morning.
Yes, ma'am.
Did you reach an agreement with him?
Yes, Your Honor.
The terms of the agreement, Mr. Risk.
Your Honor, we actually did not reach an agreement. I was informed that she has applied for renter's assistance on Monday, and she has submitted the proper paperwork with the court.
Ms.
My apologies.
Smith, I
Yes,
reviewed
ma'am.
these files yesterday afternoon and I did not see a 539 filed on your behalf. It might have been filed and just not uploaded to the files yet. But if you have made an application for rental assistance, you have 5 days from today's date to get that document filed, the DC 539. If you're not sure whether or not you've submitted that, we can get you moved back into a breakout room with court staff. They can help make sure that you have in fact filed that document. Based on the fact that you've made application for rental assistance, this case will be adjourned for one last time. That new date will be June the 25th. at 11 a.m. back here on this same Zoom ID. When you appear on June the 25th, be prepared to give an update regarding the status of your application for rental assistance, okay?
Okay, you said I didn't complete which form? Because when I spoke
There
with
is a
legal
form.
aid, he said I did everything I needed to do.
What I'm saying is there is this form called a DC 539, which puts the court and the plaintiff's office on notice that you've made an application for rental assistance, which agency you went through, and the status of that application. What I said is that I reviewed the files yesterday afternoon, and it wasn't showing that there had been a DC 539 filed. I also said that these documents that you filed don't get added to the file instantaneously. So even if you filed it, I might not have been able to see it. If you're saying that you filed it, great. If you're not sure, you want to confirm, we have court staff. We can move you into a breakout room with court staff to make sure that you've done what you're supposed to do.
Okay,
If you're saying
yes,
that you
Your
already
Honor.
talked to some. Yes, Your Honor, you want to talk to court staff, or yes, you're sure you did it?
Yes, I'd like to speak to court staff. I'm sorry for interrupting. I'm
No,
sorry.
no, you're fine. We'll get you moved in, we'll get you moved in to speak to Olivia, but I'll see you back here on June the 25th at 11 a.m. Just when you go into the breakout room with Olivia, just let her know that you want to make sure that you filed the DC 539 or the rental assistance form, whichever words you'll use, she'll know what you're talking about.
Yes, ma'am. Yes, Your
Oh,
Honor.
no. Yes, thank you. I'm sorry, I got another message, but go in with Olivia, make sure you're done. After you speak with Olivia, you're free to go.
Thank you, Your Honor.
Thank you. Oh, 2403437 LT West Village versus Alicia Howard.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
Good morning, Mr. Risk. This case was scheduled for an adjourned hearing. It was first scheduled for June the 5th. The case was adjourned because there was no service showing by the plaintiff. There was only court mail done. I reviewed the files yesterday afternoon, and there was still no proof that your office had effectuated service upon Ms. Howard by posting or personal service or by mail from the plaintiff's office.
Hi, Your Honor. Um, I only have a mailing by the court. I would have to double check on the status of the proof of service, Your Honor. I'm not sure if we could adjourn this out for a week to sort of figure that out. If you have availability on your docket next week.
I don't, sir. Respectfully, this is the second time now, so this court's inclination is to dismiss the matter. The ROA is crystal clear, and I would have addressed it with the attorney that appeared on the 5th, that service was, there is no service by plaintiff on file.
Your
So
Honor,
that
if I
being the
may,
case. Go ahead.
before we dismiss the case, can I make a call to my office and see what the status of that is?
Absolutely, sir.
Thank you, Your
I'll
Honor.
take it up again at the end of the docket.
Thank you, Your Honor. I appreciate that.
You're welcome. No worries.
Okay.
Mr. Draper and Ms. Bohannon, when Mr. Joseph comes back out, I'll recall your cases or call your cases.
Okay.
Okay.
Thank you. This is 2403498 LT. This is Maxwell versus Michael Draper. Mr. Draper, unmute yourself and state your name for me, please, sir.
Michael Draper.
Thank you. Sir, you had the opportunity to speak to Mr. Joseph this morning.
Yes.
Sir, there was an application for rental assistance made. What's the status of that application?
I spoke to them this morning and it is pending.
Mr. Joseph, I'm sorry.
They received all the information that they needed from me. The specialist just has not gotten to it yet.
Judge, we did have a chance to speak and we did come to a resolution. If we can move forward with that at this time, I would be prepared to give those proofs to the court.
Would you please, sir?
Thank you, Judge. We have a consent judgment for possession only, $2,440, rent retained, court cost $170, totaling $2,610. That amount to be paid on or before the 28th. As long as it's paid by the 28th, I advise that nothing further would happen. And if you needed more time, you could certainly reach out to management to extend him beyond the 28th. I've gone over his rights under 4.201 regarding the 3-day rescission rule. He's also given me his authorization to sign his name to this agreement.
Mr. Draper, were you able to hear Mr. Joseph just now?
Yes, Your Honor.
And was that an accurate statement of the agreement you reached with him?
Yes, because I told him that I submitted this paperwork and he said that there wasn't any proof of it. Because
There wasn't
No, I
any
said
proof of what,
we
sir?
didn't get proof of it. I
Oh,
said
no,
that
no. No, there's no proof of what, Mr. Draper?
me having this rental assistance application.
I'm sorry. Now, Mr. Joseph, what were you saying?
Yeah, I was explaining to him that we didn't get notification of it and that I could extend him to the 28th. Based on that, I didn't know if he would be entitled to an adjournment. And that's where we came to the agreement that we came to.
There is the DC 539 was filed with the court showing that he made application to DHS as of June the 2nd.
Okay. Well, it's up to him.
So
If he wants to move, if he wants to move for a 14-day adjournment, he's entitled to that based on the timeliness of the form. Then I'll defer to the court and to him on that.
Mr. Draper, do you wish to proceed with the consent judgment or do you wish the court to adjourn this matter again?
If we could adjourn for 2 weeks to give rental assistance their time to approve it, that would be wonderful.
Then, Mr. Draper, that date will be just short of 2 weeks just because of how the court schedule is. It will be June the 25th at 11:15 a.m.
Okay.
June the 25th at 11:15 a.m. for the last adjournment for the rental assistance to be processed. On that date, Mr. Draper, if your application for rental assistance remains outstanding, then we would look to enter a judgment in this case, okay?
Okay.
Anything else, Mr. Joseph?
Nothing further, Judge. Thank you.
Anything else, Mr. Draper?
No, Your Honor.
I'll see you on the 25th, sir. Have a good afternoon.
Thank you. You as well.
Thank you. This is 2403495 LT Maxwell versus Lanana Bohannon.
Joe Joseph for plaintiff.
Good morning, Lanetta Bohannon.
Good morning, Ms. Bohannon. Today is the day and time scheduled for the adjourned hearing in this matter. We were here back on June the 5th. There was a payment pending between the parties and some indication there will be some conversation regarding ballots. Mr. Joseph, you spoke to Ms. Bohannon this morning?
That's correct, Judge. We've agreed to a consent judgment for possession only. Rent retained $928, court cost $170, totaling $1,098, with a writ date of June 24th. I've gone over Ms. Bohannon's rights under 4.201 regarding the 3-day rescission rule. She's also given me her authorization to sign her name to this agreement.
Thank you. Ms. Bohannon, were you able to hear Mr. Joseph just now?
Yes, Your Honor.
Ma'am, was that an accurate statement of the agreement you reached with him?
Yes, Your Honor.
When you were here back on June 5th, there was a video that played that explained the legal rights you have available to you in this case. Do you have any questions about those rights?
No, I do not.
Do you have any questions about the consent judgment?
No, I do not.
Do you have any question about today's proceedings?
No, Your Honor.
Then Mr. Joseph's office will prepare a consent judgment that shows a total due of $1,098 with the indication that you will pay this amount or vacate the property by June the 24th, 2024. So long as his paperwork has those same dollar amounts, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this case, Mr. Joseph?
No, Judge, nothing further. Thank you.
Anything else, Ms. Bohannon?
No, Your Honor.
Ma'am, you're free to go. You have a great day.
Thank you. You as well.
Thank you. 2403490 LT Maxwell versus Jasmine Walker. Ms. Walker, please unmute yourself and state your name for me.
Hi, Jasmine Walker.
Ms. Walker, when you were here back on June the 5th, you went into a breakout room with Lakeshore Legal Aid. Will they be representing you today?
No.
Have you had the opportunity to speak to Mr. Joseph?
Yes.
Mr. Joseph, how are we proceeding?
Judge, we did agree to a consent judgment of possession with rent retained of $1,866. The court costs are $170, totaling $2,056 with the writ date of June 28th. I've gone over Ms. Walker's rights under 4.201 regarding the 3-day rescission rule, and she's also given me her authorization to sign this judgment.
Thank you. Ms. Walker, were you able to hear Mr. Joseph just now?
Yes.
And was that an accurate statement of the agreement you reached with him?
Yes.
And ma'am, you were here back on June 5th when there was a video that played that explained the legal rights you have available this morning. Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Then Mr. Joseph's office will prepare a consent judgment that shows a balance of $2,056 with the indication that you will pay this amount or vacate the property by June the 28th, 2024, so long as his documents reflect the same date and dollar amounts just placed on the record. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else, Mr. Joseph?
Nothing further, Judge. Thank you so much.
Anything else, Ms. Walker?
No doubt about it. Well, we did talk about if the apartment would allow a payment arrangement. Would that work if they allow me to proceed with a payment arrangement at that point?
That's typically something you discuss directly with the property. The
Okay.
court doesn't get involved in it, and typically the attorneys don't. And if Mr.
Okay.
Joseph indicated that you should speak to the management at the Maxwell, then you follow up with
Yes.
them, okay?
Okay.
Anything else?
I know that'd be all.
You're free to go, ma'am. You have a great afternoon.
Thanks, Judge. Have a great day.
You too. Mr. Morton. Oh, boy. Mr. Risk, any update as to Ms. Howard's file?
Your Honor, I did contact my office. Unfortunately, there seems to have been an mistake as to a different Howard that was serviced. I would ask the court, rather than dismiss the case, to set it out in order to give us time to properly serve rather than dismiss it and refile the case.
Your request is denied, sir. The case will be dismissed. The dismissal will be without prejudice.
Okay, thank you, Your Honor.
Thank you.
I do have more cases at 10:30, so I will see you in a bit.
Sounds good, sir.
Thank you.
Thank you. Um, hmm. This is 2403396 LT Parks of Belleville versus Keith Hubbard and Keith Stewart.
Good morning, Your Honor. Ryan Wojcik, P84535, on behalf of the plaintiff. Good to see you.
Good to see you, sir. Today is the day and time scheduled for the adjourned hearing in this matter. When we were here back on June the 5th, there was an indication from the parties that an application for rental assistance had been made. The court did receive the 539 showing application with DHS. Case was scheduled at 10 a.m. It's now 10:15 by this court's clock. Have you seen Mr. Hubbard or Mr. Stewart had moved out? Have you seen Mr. Hubbard this morning?
Your Honor, I think I have that backwards. I had Mr. Stewart appeared last time. They're both Keith, I know. I believe Mr. Stewart appeared last time. Mr. Hubbard had vacated. I have not spoken to him. I did speak to the manager. Apparently there's some other issues with this case as well, with this tenant, not regarding non-payment. So if the court's willing to enter it, we would ask for a default judgment.
Thank you. When we were here on June 5th, this court's policy is typically to advise people to, even with the filing of the 539, when the case is adjourned, they need to appear to provide an update regarding their application for rental assistance. This case having been scheduled at 10 a.m., it now being 10:16 by this court's clock, defendants failing to appear, sir, the court would grant your request for default judgment. The rent to retain possession, sir?
We're showing rent to retain based on the books and records of my client of $3,751.35, costs of $233.35, for a total redemptive amount of $3,984.70, and we are requesting a writ date of June 24th, 2024.
Thank you. Request is granted. Please have your office submit the default judgment with the terms just placed on the record. Anything else this morning?
No, Your Honor. Thank you very much. Have a great rest of your day.
You too, sir. Thank you.
Thank you.
Marianne, I'm out here hustling to get Dan's notes put in for him.
Hustling to do what? Oh, Dan.
We thank you, Judge.
If there's anyone here for your office, from that 10:15 block, if they're not here by 10:30, I'll call your cases, sir. Other than that. Oh, there's a Miss Lynch here. Oh, that's pallets. I'm sorry. So you have 3 at 10:15. I'll call you at about 10:30 or so. This is 2403381 LT. This is Country Meadows versus Ball and Jones. Would you state your names for the record, please?
Chantel Ball.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Country Meadow.
Thank you, Mr. Morton. You've had an opportunity to speak to Ms. Ball. How are we proceeding?
Yes, I have. The parties have spoken. We've agreed to enter into a proposed consent judgment agreement. The payment date will be June 26, 2024. Rents retained are $4,680.00. Core cost of $248.83 for a total of $4,928.83. I did advise Ms. Ball specifically that this agreement would not be final for 3 business days. Additionally, the fact that she did have the right to appeal and she did give me permission to put her name on the proposed agreement. And then finally, if I did not mention this, I thought I did, but since Ms. Jones is not here, a default will enter, but it will not change any of the terms. It will not cause the bailiff to come out and arrest her for any reason or anything like that because she is not here. She's simply not here to be able to go on the record and have the court confirm her rights and the terms of the agreement.
Thank you. Mr. Morton, my concern is that there is a DC 539 showing application with DHS for rental assistance. Ms. Ball, what's the status of that application for rental assistance?
I don't know yet. I told him I checked this morning when I left home, so I'm not for sure, and I'll check again. But if not, I will have the balance.
And ma'am, you heard the terms that Mr. Morton just placed on the record,
Yes, ma'am, I did.
and that was your understanding and agreement?
Yes, ma'am, it is.
Ma'am, when you were here back on June 5th, there was a video that played that explained the legal rights you have available. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Do you have any questions about today's proceedings?
No, ma'am, I don't.
Then, ma'am, Mr. Morton's office will prepare a consent judgment that shows a total due of $4,928.83 with an indication that you will pay that amount or vacate the property by June the 26th, 2024. So long as the document that he files matches those numbers and dates, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this matter, Mr. Morton?
No, Your Honor.
Anything else, Ms. Ball?
No, ma'am.
Then, ma'am, you're free to go. You have a great day. Good luck to you.
Thank you.
Thank you. This is 2403398 LT Country Meadows versus Prevost and Curran. Your names for the record, please.
Joseph Prevost. Ann Curran will not be here today. She just started her new job and this is her first day, so she won't be able to appear.
Oh, wonderful. When we were here back on June the 5th, there was an indication that you'd be making an application for rental assistance. The court has confirmed receipt of the DC 539 showing application with Volunteers of America had been approved. They were waiting for the W-9 from your landlord. Mr. Morton, how are we proceeding this morning?
Your Honor, the parties did speak. Mr. Provost also made me aware of the W-9, which will be communicated with my client on. The parties did agree to enter into a proposed consent judgment agreement. Was it rents retained are $2,997.47, core cost of $248.83, for a total of $3,246.30. The payment date is June 24th, 2024. I did advise them that Ms. Curran, since she's not here, would be entered as a default. But again, that does not change the terms. That doesn't change the amounts. That doesn't, as I like to tell everybody, that doesn't mean the bailiff will take any additional action or anything like that against her. Your Honor, I hear that a lot, so I always try to make sure I'm very clear that that's not going to happen. Also, he did give permission to sign his name to the proposed consent judgment agreement, and I made him aware of the fact that this is not final for 3 business days because he's not represented by counsel, and he has the right to appeal it to the higher court in 10 days.
Mr. Prevost, was that an accurate statement of the agreement that you reached with Mr. Morton?
Yes, Your Honor.
And sir, you were here back on June 5th when the video played that explained the rights you have available. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about these proceedings?
Not at this time, Your Honor. This is all pretty new to me, so I'm kind of learning as I'm going.
Do you have any questions about the default, excuse me, about the consent judgment?
No, Your Honor.
Then Mr. Morton's office will prepare a consent judgment submitted to the court, and so long as it indicates that the total due is $3,246.30, it will show as a consent as to you, a default as to Ms. Curran, that this amount will be paid or you will vacate the property by June the 24th. As long as his numbers match what was just placed on the record, I'll sign it and a copy will be mailed to you at the address we have on record. If, Mr. Prevost, if you receive information that Country Metals has failed to file the W-9 as requested and needed by Volunteers of America, please advise the court. The court will not take it kindly. Their failure to do what they need to do to get the rental assistance released to them that's already been approved, okay?
Roger, Your Honor. So to make sure I understand correctly, if they continue to not submit the W-9 to the Volunteers of America, you'll be able to assist in them making sure that happens.
I can't make them do it, but I find it difficult to believe that somebody would file a non-payment of rent case and then not do something that would result in money being released to them. Those two things don't go together for me.
Roger that, Your Honor. That's exactly what they're waiting for. I contacted them while I was in the waiting, and he said that's all I'm waiting on. And he said he'd be more than happy to talk to anybody court-wise over them.
Mr. Morton indicated that he would make his client aware of that need, so we'll see, and hopefully they'll get it done sooner rather than later. The money will get released and you'll be back on track, okay?
Yes, Your Honor. If it does not, who do I contact?
Well, I would
come
advise,
back
sir, I would first advise you that was that you would want to contact my office. You can speak to me and I can communicate with my client regarding that. But I'd anticipate that if my client has me take any action on the judgment based on non-payment and they did not submit the W-9, then there'd likely be another hearing date set by the court.
Yes, sir. So I just get or have your information. I just call you up immediately and let you know that.
Yes.
Yes, sir.
Anything else, Mr. Prevost?
No, Your Honor.
Good luck to you, sir. You have a great day, okay?
Thank you, Your Honor. You too.
Thank you. This is 2403384 LT Country Metals versus Michael Chaffins.
Christopher Chaffins, Your Honor.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Country Metal. The parties did speak. Was it Mr. Chaffins that was it is also an occupant there. The parties did come to a proposed agreement. And actually I need to confirm this and I do apologize for doing this just on the record. Mr. Chafin, since you're not technically the leaseholder, I just need to confirm that I have your permission and you are not required to do so to be able to sign your name to the proposed consent judgment agreement, but you would need to be added as a party and you'd be listed as an occupant only. You are not required to do so, but it is your option and choice if you'd like to do that.
Yes, that's fine.
Okay. So, Your Honor, what we would do is the parties did speak, entered into a proposed consent judgment agreement, rents retained, $5,311.82, court costs of $190.24 for a total of $5,502.06. Payment date is June 26th, 2024. Mr. Michael Chaffins will be listed as default, but again, that does not adversely change any of the amounts, time periods, or anything like that. Mr. Christopher Chaffins will be added as an occupant only with his signature on the proposed consent judgment agreement. I did advise, Mr. Chaffins as well, the fact that the agreement would not be final for 3 business days, the fact that there is the 10-day appeal period, as well as the fact that he did give me permission to put his name on the proposed consent judgment agreement.
Thank you. Mr. Chaffins, was that an accurate statement of the agreement that you reached with Mr. Morton?
Yes, Your Honor.
Do you have any questions about the rights you have available in this case?
No.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Then Mr. Morton's office will prepare a consent judgment submitted to the court for signature, so long as it shows you added as a party occupant and a total due of $5,502.06 that you will pay or vacate the property by June the 26th. The court will sign it and mail a copy to you at the address we have on record. It will show as a default judgment as to Michael Chaffins because he failed to appear, but as Mr. Morton indicated, the rest of the terms will be the same. Do you have any questions, Mr. Chafins?
No, Your Honor.
Is there anything else, Mr. Morton?
No, Your Honor.
Thank you. Sir, you're free to go. You have a great day.
You too. Thank you.
Thank you.
I do have one matter remaining, Your Honor. That's Ms. Lynch, who just came
Lynch.
into the breakout room.
2403413 LT. This is Van Buren Estates versus Lynch. Ms. Lynch, please turn your video on and state your name for me, please, ma'am.
Latia Lynch.
Thank you. Ms. Lynch, when you logged on June the 5th, you were going to call Lakeshore Legal Aid, which was the reason why this case had been adjourned. Did you make that call?
Yes, I did.
Are they representing you this morning?
No, they're not.
Have you had the opportunity to speak to Mr. Morton, the attorney for Van Buren Estates?
Yes.
Mr. Morton, how are we proceeding?
Your Honor, the parties did speak. We've agreed to enter into a proposed consent judgment agreement, which will be a straight move-out date at this moment. We've agreed to a move-out date of June 30th, 2024, so it'll be just a simple end of the month. I did speak to Ms. Lynch about multiple options, but we've agreed to do the straight 4B move-out, which would mean that she understands that she needs to turn over the keys on or before the 30th. As I explained, the keys, since the 30th is a Sunday, but it's the end of the month, the keys would need to be inside the drop box when they open up on Monday. Again, I did advise Ms. Lynch of her rights, specifically the fact that the agreement is not final for 3 business days. 2, the fact that she does have the right to appeal the court decision to the higher court. And then 3rd, she did give me permission to sign her name to the proposed consent judgment agreement. And again, Your Honor, this is a consent judgment agreement with just a move-out date of June 30th, 2024.
Thank you. Ms. Lynch, you were able to hear Mr. Morton just now?
Yes.
And was that an accurate statement of the agreement you've reached with him?
Yes, it was.
And ma'am, you were here back on June 5th when the court played a video explaining the legal rights you have. Do you have any questions about your rights in this case?
No.
Do you have any questions about today's proceedings?
No,
Do you have any questions about the consent judgment?
I do not.
Ma'am, inasmuch as you have entered into this consent judgment with the court, I'm sorry. Insomuch as you have entered into an agreement with Mr. Morton that you will vacate the premises at Van Buren Estates on or before June 30th, 2024, the court will convert this matter from a non-payment to a termination case. Mr. Morton's office will prepare a consent judgment so long as that judgment contains the same terms as were just placed on the record. The court will sign it and a copy will be mailed to you at the address we have on record. Mr. Morton, is there anything else in this matter?
No, Your Honor.
Thank you. Anything else, Ms. Lynch?
Okay.
Ma'am, good luck to you. You're free to go. You have a good day.
You too.
Your
Thank
Honor, I
you.
believe that's my last matter for the day, and I think now I get to go spend time with Judge Oakley.
Have a good day, Mr. Morton.
Thank you, Your Honor.
This is 2403380 LT. This is Swan Creek versus Donovan and Qualls. Your appearances for the record, please.
Jessica Donovan and Matthews at work.
Alex Lubianski, P77121 on behalf of plaintiff. Your Honor, my apologies. I'm in a concurrent court. We do have a consent here, but I'm sorry. I'm just trying to manage both.
Are you actively on the record in the other courtroom?
I am, Your Honor.
Thank you. I just don't like the parties to wait, sir. Finish up your other hearing, Ms. Donovan. As soon as he's done, he'll come back over to this room and we'll take the terms of the consent.
Thank you, Your Honor. My apologies.
Yes, ma'am.
Marianne, if he comes back, I'll be right back out.
Okay.
My apologies, Your Honor.
Thank you.
We have an attorney out of town and I'm booked. So I'm just here now.
No, listen, it's fine. When you let us know, it's a little easier for us to kind of move people around and everything. But we're on the record with Ms. Donovan. You've indicated that Mr. Qualls was at work. You've had the opportunity to speak to the attorney. How are we proceeding this morning?
So, Your Honor, I would move for a consent as to Ms. Qualls and then a default under the same terms for her husband, the other named defendant. And we do have an agreed upon consent judgment for possession only. Amount of rent currently due, $3,080.55. Court costs of $220.32 for a total of $3,387 with a writ date of June the 24th. I did explain MCR 4.201 and Ms. Donovan Qualls gave me permission to sign electronically on her behalf.
Ma'am, what's the status of your application for rental assistance with DHS?
I have a phone interview with them on Friday.
And ma'am, the attorney, the terms he placed on the record, was that an accurate statement of the agreement you reached with him?
Yes.
And ma'am, you were present back on June 5th when the video played that explained the rights you have available. Do you have any questions about your rights in this case?
No, Your Honor.
Do you have any questions about today's proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then ma'am, his office will submit a consent judgment as to you, a default as to Mr. Qualls, that indicates that $3,387 is due and owing, so long as you need to pay that amount or vacate the property by June 24th, 2024. So long as the document that he files matches those dollar amounts exactly, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of Swan Creek?
Nothing further, Your Honor.
Anything else, ma'am?
No, ma'am.
Then ma'am, that concludes this matter. You're free to go. You have a good day. Good luck to you.
Thank you. You too.
Thank you. This is 2403401 LT. This is Swan Creek versus Mino and Rourke. May I have your appearances, please?
Alex Lubianski, P77121 on behalf of plaintiff.
Andrea Mino on behalf of the defendant.
Mino, thank you. And ma'am, the second defendant failed to appear last time. Do you know where they are?
They are at work today.
Thank you. You had a chance to speak to the attorney?
I did, Your Honor.
Did you reach an agreement, sir?
We did, Your Honor. I would seek to enter it as a consent to Miss Mino and a default to Rourke. Amount of rent currently due $1,237.33. Costs of $220.32 for a total of $1,457.65 with a writ date of June the 24th. I did explain MCR 4.201 and Ms. Mino did give me her permission to sign electronically on her behalf.
Ma'am, was that an accurate statement of the agreement that you reached with his office?
Yes, ma'am, it was.
And you were here back on June 5th when the video played that explained the rights you had available to you. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No, ma'am. I spoke with the Lakeshore Legal Aid and they gave me their advice.
Oh, wonderful. Then ma'am, his office will prepare a consent judgment that shows a total of $1,457.65 that you will pay this amount or vacate the property by June the 24th, 2024. It will enter as a consent judgment as to you, a default judgment as to defendant number 2. The terms will be the same. So long as the document submitted by the attorney's office matches those dollar amounts, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of Swan Creek?
Nothing further, Your Honor.
Ma'am, anything else? Any other questions?
No, thank you, Your Honor.
Thank you. That concludes this matter. You're free to go. You have a great afternoon.
Thank you, you too.
Thank you. 2403403 LT Swan Creek versus, it was Nicholas Petway Turner. This case was scheduled at 10:15. It's now 10:53 by this court's clock. I am looking in the breakout rooms. I do not see that the defendant has appeared.
Your Honor, we have Leah from Swan Creek here as well. For some reason, I'm not seeing that case on my calendar today.
He was here on June the 5th and was to make an application for rental assistance, but the court has not received the DC 539. Let me just look back here. Nicholas Petway Turner.
Okay, I did find that defendant's name. I'm showing June the 25th as the adjourned court date, at least in our case management system.
Well, I go by the ROA, and the
Of course.
ROA says today at 10:15.
Okay, and this is an adjourned hearing, Your Honor?
Correct. He was here on June the 5th, had applied for rental assistance, and I told him that he had 5 days to file the 539. The case would be adjourned to this morning at 10:15. When this case was heard back on June 25th, I wasn't giving out that 6/25 date.
Sure.
And
based
I
on
checked the
that,
file
I
last
do- I
night,
do
and I'm looking
have
at the
the
file
file
right
in
now.
front of me.
I'm sorry.
I do have the file in front of me. If the court would allow, I would move for a default.
I will. Ms. Hubbard was disagreeing with me. Ma'am, do you have something different?
He had an appointment that was scheduled with the Border Patrol.
You are, Ms. Hubbard, thank you so very much.
Excellent. I'm glad you're here.
Oh, thank you. Oh, it was a date that he had been waiting for. Thank you.
You're welcome.
And I did not go back in and change that. You are wonderful. Thank you, ma'am.
All right.
Oh,
Oh,
wow. Do you have a time, Ms. Hubbard? You're muted. If you don't have a time, I'll have to pull my notes from the.
I don't
from
have it
June
in
the
front
5th.
of me.
he has a Border Patrol interview on the 12th, which is today. And then
Yes.
court is closed on June 19th for the court holiday. And that is where we got the adjourned court date of June 25th at 8:45 a.m.
I was
8:40.
Yes, it was early in the morning.
Thank you, Ms. Hubbard. It's coming back to me now because I have a 9 o'clock case and I wanted him to come in first because he was going to make payment if the rental assistance didn't resolve it. And I just didn't update our ROA. Thank you so much, Ms. Hubbard, for I saw you disagreeing with me and I appreciate that. Dan, I'll update my notes and get it fixed downstairs so that he's back at 8:45 a.m. on June the 25th. I don't even remember using that date. Anyway, thank you, Ms. Hubbard. We'll get
you're
the matter
welcome.
rescheduled, get notice out to Mr. Petway Turner, and I hope everything went well with his interview. This is 2403379 LT Swan Creek versus Amy Schroeder.
Alex Lubianski, P77121 on behalf of plaintiff.
Ma'am?
Yes, I'm right here, honey. Amy Schroeder.
Thank you. Ms. Schroeder, you had the opportunity to speak to the attorney this morning for Swan Creek.
Yes, I did.
How are we proceeding?
Your Honor, we do have an agreed upon consent judgment. It's possession only, amount of rent currently due $1,186.95. Cost of $177.66 for a total of $1,364.61 with a writ date of June the 24th. I did explain MCR 4.201 and Ms. Schroeder gave me her permission to sign on her behalf when I submit this to the court.
Thank you. Ms. Schroeder, when we were here back on June the 5th, you indicated that you were making application for rental assistance. Did you do that, ma'am?
Yes, I went through DHS and I just got a thing from them this morning. They need one more paper. So I'm going to turn that paper in and hopefully they'll pay everything.
Ms. Schroeder, the issue is that when we appeared on the 5th, I would have advised you that you had 5 days to file the form that's called a DC 539. when I looked at your file about 24 hours ago, it didn't show that you had filed that document. Have you done that?
Yes, I did. I did file that.
When?
The day after the court.
Sir, I'm not trying to upset your consent judgment. I just did not see and do not see the DC 539 filed in this matter.
I understand, Your Honor.
Ma'am, I don't see, I'm looking in the file right now. I don't see that that document was filed. I know that court staff is checking too. Because it's not filed, the court cannot stay these proceedings further and would enter the consent judgment. But I want to just inquire of you. You were present back on June the 5th when the video played that explained the legal rights you have available in this case. Did you have any questions about those rights?
No.
Do you have any questions about the consent judgment that you agreed to this morning?
No.
Do you have any questions about today's proceedings?
No.
Then ma'am, Mr. Lebansky's office will submit a consent judgment to the court that shows a total due of $1,364.61. It will indicate that you will pay this amount or vacate by June the 24th. So long as the document filed with the court shows those same numbers, the court will sign it and a copy will be mailed to you at the address we have on record. Was there anything else on behalf of Swan Creek?
Nothing further, Your Honor.
Anything else, Ms. Schroeder?
Nothing.
Thank you. Ma'am, you're free to go. You have a great day.
You too.
Thank you. Two four zero 3 LT Trilogy, no, 2403404 LT Swan Creek versus Small and Small.
Alex Lubianski, P7712 on behalf of plaintiff. Your Honor, this is the final party that was here that I did not yet have an opportunity to meet with. I would inquire quickly of the court, is there a DC 539 on file on this one?
I did not see one as of 11:34 yesterday.
Okay. Could I enter a consent on the Metro Commons matter that has been here? And after that, I'll meet with Ms. Small in a breakout room. Would that be possible?
Absolutely. 2403507 LT Metro Commons versus Brandon Hirsch.
Alex Lubianski, P7712 on behalf of plaintiff.
Mr. Hirsch, unmute yourself and state your name for me, please, sir.
Brandon Michael Hirsch.
Thank you. The consent judgment, sir.
Yes, having had the opportunity to meet with Mr. Hirsch in a breakout room, we have a possession-only consent judgment. Amount of rent currently due $1,385.84. Court costs of $205.36 for a total of $1,591.20 with the writ date of June the 24th. I did explain MCR 4.201, and Mr. Hirsch did give me his permission to sign electronically on his behalf.
Thank you. So were you able to hear the attorney just now?
Yes.
And was that an accurate statement of the agreement you reached with his office?
Yes, sir. Yes, ma'am. Yes, ma'am.
No worries. And you were present back on June 5th when the video played that explained the legal rights you have available in this case. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Do you have any questions about today's proceedings?
No, ma'am.
Then his office will prepare a consent judgment that shows a total of $1,591.20. It will further indicate that you will pay that amount or vacate the property by June the 24th, 2024. So long as the document that he files matches those dollar amounts, I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of Metro Commons?
No, Your Honor. Thank you.
Anything else, Mr. Hirsch?
No, ma'am.
Sir, you're free to go. You have a great day. Good luck to you.
You as well, ma'am. You have a lovely day.
Thank you.
And Your Honor, would you, I believe there's a default for Metro. Would you like me to do that now or after I speak with the other defendant?
You're talking about the, was it 1045 case?
1015, Your Honor. Last name was B-U-R-Y, Burry.
They're in your waiting room.
Oh,
They're at
here.
1045.
Oh, we had it wrong in our, okay, very good. I'll meet with them as well. Thank you.
Thank you. This is 2403519 LT Trilogy versus Randy Jackson. Mr. Jackson, unmute yourself, turn your video on and state your name for me, please.
Yes, my name is Randy Jackson.
Thank you, Mr. Jackson. Did you have the opportunity to speak to the attorney for Trilogy this morning?
Yes, I did.
Did you reach an agreement?
Yes, we did.
Mr. Risk, the terms of the agreement.
Yes, Your Honor. The terms of the agreement are as follows. Back rent in the amount of $3,296.90. Court costs are $182.68 for a total $3,479.58. And that'll be on or before June 26, 2024.
Mr. Jackson, was that an accurate statement of the agreement that you reached with Mr. Risk?
Yes, for the amount of $3,479.58 by June 26th.
And sir, you were here back on June 5th when the video played that explained the rights you have available this morning. Do you have any questions about your legal rights in this case?
No, not currently at the moment because I haven't received any feedback as far as my SCR applications and things like that. So this is currently what I have to work with.
Do you have any questions about today's proceedings?
No, I do not.
Do you have any questions about the consent judgment?
No, because either pay or vacate, correct.
Then Mr. Risk office will prepare a consent judgment filed with the court that shows $3,479.58 that you will pay this amount or vacate the property by June the 26th, 2024. So long as the document he submits matches those dollar amounts, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this case, Mr. Risk?
No, thank you, Your Honor.
Anything else, Mr. Jackson?
No, that's all, Your Honor.
You're free to go, Mr. Jackson. You have a great afternoon.
Thank you. You do the same.
Thank you. This is 2403528 LT. This is Trilogy versus Anita Strode.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
This is Anita Strode.
Good morning, Ms. Strode. The court did receive your DC 539 showing application for rental assistance. What's the status of the application, ma'am?
It is still pending.
Did you have a chance to speak to Mr. Risk this morning?
I did.
How are we proceeding, sir?
Oh, I'm sorry, Your Honor. Your Honor, we did reach an agreement to enter into a consent judgment. I can place the terms on the record if you'd like.
If you would, please.
Yes, Your Honor. Back rent in the amount of $3,090.84. Court costs of $182.68. Total $3,273.52. And that will be paid on or before June 26, 2024.
Ms. Strode, was that an accurate statement of the agreement that you reached with Mr. Riss this morning?
Yes, ma'am, it is.
Ma'am, you were present back on June the 5th when the video played that explained the legal rights you have available. Do you have any questions about the rights available to you this morning?
Yes, ma'am. The only question I have is, does that SER that I applied for, I'm not sure, does that help in any way since I am agreeing to pay by the 26th? Does that, how?
I'm not sure what you mean by help, Ms. Strode. Help me.
I'm not sure, like, yes, I did apply. They said, I guess legally I have to give them 10 days to receive an answer. You know, and I know that when you go around to ask for assistance, they normally need a denial letter. And they said I do need 10 days. I'm sorry, that they can give it anytime within 10 days. So I'm not sure if that would be enough time. So yeah.
Are you asking for more time before you agree to?
I'm not exactly sure because I've never been in this situation before. So I was just trying to find out by applying for the assistance for the rental. I know they said it takes about 10 days to get a decision. And so a lot of places that would help, they need a denial letter to show that I was, that if I am to be denied, and then you know, to apply for assistance. So I was just asking, you know, because I know the date that I was given is the 26th. So I didn't know if that was ample time to wait for an answer, to go around and try to get assistance before the 26th.
Okay, Ms. Strode, are you asking for more time to get a response from DHS regarding the SER?
If I can, I'm not sure how long it would take to get a response so that I can get assistance. So I've never been in this situation, so I'm not.
Ma'am, I understand, and what we will do, Mr. Riss, the court will deny the request to enter a consent judgment at this time. Ms. Strode did in fact file a DC 539 yesterday at about 1:54 p.m. She's asked for more time to allow that request for assistance to be processed. Ms. Strode, the court will adjourn your case for the last time to June the 25th at 11:15 a.m. If DHS has not made a decision regarding the application at that time, we will revisit the request for consent judgment and enter it on that date, okay?
Okay, thank you so much.
Anything else, Mr. Risk?
No, thank you, Your Honor.
Anything else, Ms. Strode?
That is, thank you so much.
No worries, ma'am. I'll see you on June the 25th at 11:15 back on the same Zoom ID.
Thank you.
Have a good day.
You too.
This
Have a
is
wonderful day.
Thank you. This is 2403526LT Trilogy versus Brandon Robinson.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
Brandon Robinson. This case was scheduled at 10:30. It's now 11:12 by this court's clock. Defendant has failed to appear, sir. How would you like to proceed?
Your Honor, at this time, we are requesting an entry of default be entered against the defendant based on their failure to appear. Back rent in the amount of $2,542.65. Court costs of $182.68. Total $2,725.33.
Thank you. Please have your office submit that default judgment for entry. This is 2403514 LT Trilogy versus Jenny Caldwell.
Good morning, Your Honor. Ali Risk on behalf of plaintiff.
Ma'am, state your name for me.
Jenny Caldwell here as well.
Ms.
Jenny
Caldwell, when
Caldwell.
we were here back on June the 5th, you asked for more time. You were seeking help from your church and from Helping Hands. Have you received any assistance?
I am going to get some assistance from my church, and then I have agreed to pay the remaining balance by the 28th.
The terms of that agreement, Mr. Risk?
Yes, Your Honor. There's back rent in the amount of $2,471.11. Court costs of $182.68. Total $2,653.79 on or before June 28th.
Thank you. Ms. Caldwell, was that an accurate statement regarding the agreement you reached in this matter?
Yes, it was, Your Honor.
And ma'am, you were here back on June 5th when the video played that explained the rights you had available in this landlord-tenant matter. Do you have any questions about those rights?
I do not.
Do you have any questions about today's proceedings?
Nope, I think I'm good.
Do you have any questions about the consent judgment?
No, I do not, Your Honor.
Then Mr. Risk office will prepare a consent judgment that shows a total due of $2,653.79. That you will pay this amount or vacate the property by June the 28th, 2024. So long as the document that he files matches those dollar amounts and the date, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else, Mr. Risk?
Oh, thank you, Your Honor.
Anything else, Ms. Caldwell?
No, Your Honor, and I thank you for both of you for your time.
Thank you.
No worries, ma'am. You have a good day. You're free to go.
Thank you, you too.
Thank you. 2403522LT, Trilogy versus LeBerry and Burrow.
Makai LeBerry.
Anna Burrow.
Thank you. Today is the day and time scheduled for the second hearing in this matter. Have you had the opportunity to speak to the attorney for Trilogy?
Yes.
Yes, we have, Your Honor.
Mr. Risk, how are we proceeding?
Your Honor, we've entered into an agreement in the form of a consent judgment. Defendants, I believe, intend to vacate. However, there is back rent in the amount of $2,519.67. Court costs of $233.71. Total $2,753.38. That's on or before June 26th.
Ma'am, were you able to hear the attorney just now?
Yes.
And was that an accurate statement of your agreement?
Yes, ma'am.
Sir, same question. You were able to hear the attorney and that was an accurate statement of your agreement?
Yes, Your Honor.
When you were here on June the 5th, there was a video that played that explained the legal rights you have available. Do either of you have any questions about those rights?
No, ma'am.
No, ma'am.
Do you have any questions about today's proceedings?
No, ma'am.
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
No, ma'am.
Thank you. Then Mr. Risk's office will prepare a consent judgment that shows a total of $2,753.38 due and owing. The judgment will indicate that you will pay this amount or vacate the property by June 26, 2024. So long as the document he files with the court matches those dollar amounts and the date, the court will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this case, Mr. Risk?
No, thank you, Your Honor.
Anything else, Ms. Burrow?
No, ma'am.
Anything else, Mr. Labari?
No, ma'am.
Then you're both free to go. You have a good afternoon. Good luck to you.
Thank you.
You too.
Thank you. 2403523LT, Trilogy versus Nicole Morris.
Yes.
State your name, ma'am.
Nicole Morris here.
Thank you, Ms. Morris. Today was the day and time scheduled for the adjourned hearing in this matter. Mr. Risk, how are we proceeding?
Your Honor, we were not able to enter into an agreement. I have been informed by the defendant that they are, I believe they're going to seek representation. And they
I'm sorry,
stated-
sir. I'm sorry. When you turn your head, I lost you. You say you spoke to her and I'm
Oh,
sorry,
I'm
what after
sorry, Your
that?
Honor. I apologize. She said she's going to be seeking legal representation. and we could not come to an agreement.
Ms. Morris?
Yes, ma'am. My issue was the extra $300 they want me to pay for not having a lease. I
The
just
month
didn't
to
understand.
month?
Yeah.
Okay.
I just didn't understand. I really didn't understand that part, especially being that I was late last month and we already had a case where I was supposed to pay the $1,461. When I went in on the 24th, they told me I couldn't pay it because we were already in litigations. And then I'm just not getting the $300 fee, but I really want to be over this. So I heard you say that they was going to a lady to the 28th. I'll agree to the consent order and try to get this done by the 28th because I get a check in between now and then. So I have $2,300 now. I should be able to come with the the $3,000. I'm just a little upset about the extra money that they're charging me for the lease, and they wouldn't accept the money that I had. I only owed them the $1,461. They wouldn't accept that last month because we were in court, or they had to go to file the court case. I'm in between a rock and a hard place. I don't know what to do. I really don't.
Ms. Morris, I don't know what the extra $300 is. When we were here last, there was a question of $1,400 that you tried to tender that they wouldn't accept because this case was pending. And then there was another $400 from DHS that your landlord needed to submit a W-9 to have that money released.
They say they don't do that. They don't accept payments from MDHHS. And I'm like, well, why did they tell me to seek for assistance if y'all don't accept the assistance?
Ma'am, did you want to speak to a representative from Lakeshore Legal Aid?
I think I need to speak to somebody just to be clear.
If Ms. Becker's available, we'll get you moved into a breakout room with them. We have some other cases. We can circle back to this one.
Okay.
Ms. Becker? This is 2403505 LT Metro Commons versus Whitney Berry.
Alex Lubianski, P77121 on behalf of plaintiff.
Whitney Berry? I can see them, and I know staff is trying to get them to unmute, say their name for the record.
Yes, can you hear me now? Whitney Berry is here?
Yes, ma'am.
Okay, great.
Thank you. Ma'am, did you have the opportunity to speak to the attorney this morning for Metro Commons?
Yes, I did.
How are we proceeding, sir?
Your Honor, there's no dispute as to the amount. Ms. Berry has indicated that she has filed DC 539 and that she's still seeking assistance. So I would defer to the court.
Can I say something, Your Honor?
Yes, ma'am. I was going to ask you, what's your position in this case right now?
So the attorney had mentioned a date of the 24th, like to get caught up, and I was asking if I could have until the 26th, and I would be able to pay everything in full by that date. I don't know if that's possible, whether or not I get assistance. The application is still in process, but pending that I don't get assistance by the 26th, I can have
And Your Honor, that is an accurate statement of our conversation. I only have authority to go until the 24th with our client. So that is an accurate statement.
Well, the court is showing that there was a DC 539 filed on June the 10th. That rental assistance have been applied with through Michigan Department of Health and Human Services and remains outstanding. And Ms. Berry did in fact attach proof that that application was pending. So the court's inclination would be to stay the matter until the June the 25th date
Very
at
good.
11:15 a.m. Ms.
Okay,
Berry,
and
that means that, I'm sorry.
No, go ahead. I'm sorry.
I was saying that means that will be the last adjournment of this case to June the 25th at 11:15 a.m. And if DHS has not made a decision regarding your application, the court would entertain entry of judgment at that time. But that means that you have until the 25th to follow up and make sure that be able to come back to the court on the 25th and provide an update regarding your application for assistance and have a conversation with the Cox Law Firm regarding any past due amounts and ability to make payments, okay?
Okay, does that mean that I would be able to pay it in full the following day if, you know, the application, you know, I don't end up getting assistance?
Correct.
Okay, that would be great.
Okay, so I will see you back here on June the 25th at 11:15 a.m. Is there anything else in this case, sir?
Nothing further, Your Honor. Thank you. Good luck, Ms.
Anything else,
Berry.
Ms.
Thank you.
Berry?
No, I'm good. Thank you very much.
You're free to go, ma'am. You have a great afternoon.
You as well.
Thank you.
Thank
Is
you.
that it, sir?
Your Honor, there is a consent on Swan Creek v. Small, and that is our last matter this morning. It was a 10-15 case.
Right, you were checking on that. Thank you. And 2403-404 LT Swan Creek versus Small and Small.
Alex Bianski, P77121 on behalf of plaintiff.
I don't recall seeing them this morning. You talked to them in the breakout and entered a consent with them this morning?
Your Honor, very recently. They were here. They're still here, I believe. And we met in the breakout room maybe 10 minutes ago. If not,
I'm looking at, I don't see them. But
They're not here
what
anymore,
were the
Your Honor?
terms of the agreement?
well, if it helps the court, Your Honor, they did not file a DC 539, so the terms were the same as if we did hold a hearing. We had a total redemptive amount inclusive of costs of $3,458.91 with a writ date of June the 24th. Our office would move for entry of judgment either by consent and they zoomed out, or by default, or by hearing, but really the same terms, Your Honor.
I need the difference with the rent and the court costs from me, please, sir.
Yes, Your Honor. In rent, $3,238.59. Court costs $220.32 for a total of $3,458.91.
Sir, I will enter it as a default judgment, showing them as having failed to appear at 11:27. The reason I do that instead of a consent is that that new box on the consent form that requires the knowing waiver of the rights. I don't
Understood.
like to do that unless I've been able to inquire directly of them. So if you submit it as a default, I will enter it as such.
Very good. We will do so and have it overdue this morning. Thank you, Your Honor.
Thank you, sir.
All right. You have a great day.
You too. Thank you, Ms. Hubbard. Good to see you.
Thank you. Have a great day.
You too. Good morning, Ms. McLemore.
Hello, Your Honor.
Yes, sir.
Your Honor, I do have another obligation, relatively shortly. I do apologize. I hate to do this.
No, no, sir, don't apologize. I see that the attorney for Lakeshore logged on. So for the Morris matter, let's find out real quick from Ms. McLemore what's going on, and then I'll let you get on with your day. Ms. McLemore, good morning.
Good morning, Your Honor. Danette McLemore, I did get an opportunity to speak with Ms. Morris, and we will be able to provide her with some assistance in this matter. I would like to have an opportunity to file an answer to the complaint against her. There was an issue regarding it. It seems, I believe that the late fees that she's being charged are excessive. She's telling me that she's paying, it's like $50 for the very first week, then it's $100 for the second week, then $150. So, and my understanding is that this is the second date in this particular case. But when she had tried to pay it last month, they would not accept it because they had already started this case. And therefore there were court costs, and also the plaintiff, my understanding, will not, even though she was approved for some assistance through SCR, they will not accept the SCR payment from the state of Michigan.
Ms. McLemore, this is 2403523LT Trilogy versus Morris. I'll note that you were here and your comments. Mr. Risk needs to get somewhere else. So let's adjourn this matter over for the last time to June the 25th at 11:15 a.m. If you speak to their office between now and then, we'll be ready to move forward on the 25th at 11:15.
At 11:15. Okay, thank you, Your Honor.
Thank you, Your Honor.
I will give you a call, Mr. Risk, if that's okay.
Yes, absolutely. Thank you.
Thank you.
Okay,
And Ms.
thank you.
McLemore, if you're going to take care, Mr. Risk. Ms. McLemore, if you're going to continue to meet with Ms. Morris, we'll stop recording and we'll stop streaming. We'll leave the Zoom up, but staff won't be here.
Okay, thank you, Your Honor.
Okay, thank you,
All right,
ma'am.
thank you.